we're running a bit late. Sorry, because we were just recording
my podcast.
And we're halfway through it, so fix it up.
Tara's kindly been helping me out with one of my podcast episodes, and she's come up with 10 reasons that you need a new estate plan after separation. So it's very interesting.
Well, what I might do, we're just waiting for a few people to come on. Hi Jacinta, hi Phil. So I'm here with Caralee Fontenele. Not only is Caralee a very dear friend of mine, but she is one impressive woman. So she is the principal of Caldwell Family Lawyers, where we're sitting in. Check out my story, actually, because I did a little tour of her reception, which isn't really a reception. It's such a cool space. So yeah, day job, just, running a law firm, a family law specialist law firm. She also has her podcast called Divorce Confidential. She has written 2 cooking books.
Yeah, 2 cookbooks.
Just in her spare time, 2 cooking books, all about healthy food, called The Real Food Pledge. How many, Instagram followers do you have?
Not that many on Instagram, but a fair few on Facebook.
Oh, you've got over 10,000.
I've got 12,000.
You've got the swipe up, which...
I've got the swipe up.
She's famous. And you have just started building and launching an online training course
for people who go through divorce and separation. So in Australia, interestingly, 71% of people don't retain a lawyer. So what do? Google, I guess. So I've created an online course to help the 71% of people who really just need some guidance through the process on how to manage it, how to negotiate with their ex, because that's one of you might know where you stand. We can all find that information out and make some educated guesses about what you might be entitled to, but how do you actually negotiate with your ex-partner when you say the sky is blue and they say it's red, which is a typical scenario. If you've ever been through divorce, you'll understand.
And so, I think it's fair to say we started becoming good friends because we're sort of have this joint mission where 70-something% of Australians don't get family law advice. 75% of Australians don't have a will. So we've been looking at ways to innovate delivery of
create
solutions.
More impact on the people out there that are looking for solutions. Who don't necessarily and understandably want to spend $10, $50, $100,000 on family law litigation, which who does?
Yeah, exactly. Yeah. And so we sort of going on this journey of using
technology,
online stuff and marketing and but what I wanted to talk about today is we've had some great questions come through about the intersection between family law and estate law. I've got a few questions for you as well, and I really wanted to get Caralee on the live because we come at it from different angles. I think I'm always trying to protect assets from family law. You might be protecting them, but you also try and access them depending on who you're acting for. And a lot of it is, I kind of look at the theory and the cases, but you're seeing these matters come through the firm practically. And the problem, I guess, with relying on cases is so many get settled.
Well, the problem relying on any case law or even legislation is that to get to a trial in the family court or the federal circuit court can take maybe 2 years. And will cost one party around between $50,000 and $100,000 before you're sort of even at the trial. And then even you might get your day in court and then you're settling before you're setting foot in the courtroom, or you're halfway through the trial and you settle, or you get through the trial but then you don't actually get a result or a judgment for months in advance. So that's a real problem for people. So a lot of the time family law, we are really about negotiating outcomes that both parties can live with, because let's face it, no one wins in family law. That's sort of where we're at. And, you know, the court is just slow.
Yeah.
And even as lawyers, it's hard to advise people on the outcomes that they're going to get, because the judge has full discretion in the Federal Circuit Court in family law. So it's often completely dependent on the judge that you get as well.
Yeah. So my first question,
Yeah.
putting you in the hot seat, what happens when a party dies halfway through a family law property settlement?
Okay, so I've actually dealt with a few of these, and it totally depends on the circumstances. But if a party dies through a family law process, so you've separated, you've both engaged lawyers, and but you're not in any court process yet, there is no claim. So the property settlement basically dies, and all of the assets go to the living spouse. Basically.
Yeah.
So
under the estate law, they go to the spouse.
Yeah.
So then
The family law, there's no claim, and the family law matter. So say, for example, someone passes away and we're not in a court process yet, and say this did happen in our firm a couple of years ago. It was a very sad circumstance. We had a matter where it was very high intensity, full of emotion, and the we were acting for the husband. He was only 30 odd years old, and he had full care of the children, and he passed away during the process, and they'd been separated for nearly a year. It was pretty ugly, and she just swept on in. Parents of the 30-year-old husband, the siblings, none of them had any rights to anything, not even his personal belongings. So you can understand, when they'd been living separately for a year or so, how upsetting that was to the family. Yeah. Compared to another matter we've had more recently, it was an older couple. He was getting close to passing away within months, because he had already an illness, and so as a way of protection for the family, we filed in the Federal Circuit Court to keep the matter alive, so that after he passed away, the family could still litigate for his portion of the property pool.
Okay, so
if you are in the court process, what that means is that it's on foot, and then the family, so the estate, can then continue the family law process. So, you know, that, for example, like particularly if there's step parents and children and things like that, when it can, you know, get a little bit more awkward, that makes a lot of sense. In that way. So that's why in that case we did file. Okay,
so court proceedings, they can continue, but if you're just doing consent orders
or just negotiations, so your family law process starts, the majority of matters don't end up in court. Like I said before, 70% of matters don't even retain a solicitor, or 70% of people don't retain a solicitor. So the majority of matters aren't filed, and unless you have hindsight that someone's going to pass away, which we did in that matter I was describing before, there's no way of knowing, and you only need to file in the court process if there's something going on. And so, we might spend 5 months or 10 months negotiating without being in a court process, and the negotiations might be going quite well, in terms of you getting closer to a settlement, and there's no need to file, and we're trying to keep that out of court, and all the parties are on board. But if that person passes away,
game over.
Game over.
Which is why, I know this is mirror image, but I put the link in and I'll share it again. You have to get your client to update their estate planning right upon separation. Don't wait till divorce. Don't let it drag out. And I know your clients are going, oh, we don't want more lawyers in our lives. But as advisors, so whether you're a family lawyer or an accountant or a financial advisor, if you know your client is getting separated and about to embark on a process or putting their head in the sand because they don't want to, you have to get them to update their estate plan straight away.
Absolutely. And the matter where I described before that the husband passed away, there was no will.
Yeah.
So then, as you explain, it was back to the default, and so then the ex-partner could swoop on in, and there was nothing that the family could do about his portion of his property settlement that would have been his.
And Caralee, you just explained this to me in our podcast episode, but basically, divorce is just the rubber stamp at the end of the process. You have to be separated for 1 year.
You have to be separated for 12 months before you can get a divorce, and then even then you are separated for 12 months before you can file for the application. And in at least Queensland at the moment, the process takes about 3 months, and then you're not really divorced for another 4 weeks after that, or 28 days after that. So really, there's no possible way of being divorced until you have been separated for at least 14 months overall.
So there's a real mismatch in my mind, because I don't think most people will stop being a spouse under the succession and intestacy rules until they've been divorced. So even if they've done a property settlement but don't have that rubber stamp of divorce, they're entitled under intestacy. So big gap there. Now I think the question that we had coming through and that sparked this whole idea of collaborating to do the live is, what happens in a family law matter when the parties receive an inheritance? So
this is a big one, and it comes up a lot. And I often wonder, like on a side note, why it comes up so often. And sometimes, people have been, the inheritances happen all the way through relationships, which I'll talk to you about. But often they happen at the end of a relationship, funnily. And sometimes I think that people receiving a large inheritance, it's kind of like their get out of jail card, that they, it's like, oh, I've got all this money now to get on with my life, and I really don't want to be sharing it with my husband or wife because things aren't going well. And then the relationship comes to an end. So often, that's just kind of a little side note of things that I notice, but often we are dealing with property settlements that include inheritances. Often we're dealing with inheritance that comes at the end of the relationship.
Okay.
Yes, and it's treated completely differently whether it's during the relationship or at the end of a relationship. So we look at contributions. So in family law, the first step of the family law process is, what assets have we got? It's really important to know in family law that nothing is protected at all, basically. So it could be your name, her name, his name, joint name, business name, or a trust. It's all included in the property pool. So we get a figure, the net figure of whatever is in the property pool, and then from there we look at a couple of main items as to how to divide it, so what percentage each party receives. And one of those main areas is contributions.
Okay. And
contributions come in the way of initial contributions, so what you came in with at the beginning, and contributions during the relationship, and post-separation contributions. And often we're dealing with inheritance during the relationship, so people who have received an inheritance during the relationship, and people who have received an inheritance at the end of a relationship or post-separation. So it's dealt with differently in all of those different stages. And of course it depends on how long the relationship is and all of that kind of thing. But as a general rule, inheritance is included in the property pool. And but it depends when the inheritance has come. So if the inheritance has come within the last few years, and is still kind of separate, or towards the very end of the relationship, like in the last year or so, or post-separation, then it can be kind of extracted.
Yeah.
If an inheritance has come during the relationship and they've spent this on renovations and this on paying off the mortgage, and they've been, living their lives for the last, 8 years or 5 years or whatever it might be, it's really hard to not have it included.
Yeah.
Yeah.
So tell me the difference between resource and, is it property?
So when we work through the 4-step process, we're really looking at the asset pool. So that's actually all of the equity in the assets. If everything was liquidated, how much money would there be? So that includes anything and everything. Super, cars, property, shares, cash, all of that type of thing. And obviously inheritance gets brought into the pool at some point, and usually it gets intermingled. It often does.
And can the court can the parties make different agreements about, like if there's an asset that's only considered a resource, then that can't get an order, like you can't be ordered to pay that resource asset to a spouse?
So if there's a resource, so the difference between an asset and a resource is that an asset is a solid cash, like that, whatever the asset is liquidated, I guess you could say. And then a resource is like a financial resource, so that's whatever finances are coming in per week or per month. So it's treated differently, and the resource is really treated like income.
Yeah, so it's not divisible property if it's a resource.
If it's a resource, no.
But if it's property, it is. So this is where the whole testamentary trust, it's just worth its absolute weight in gold. Because to me, if you receive an inheritance not in a testamentary trust, so directly, then the starting point is that inheritance is in the property pool.
It's in the property pool.
And then you got to look at the contributions and blah, blah, blah.
And it can be very hard, especially if it's been intermingled.
Yeah.
Or even if it's been sitting in a bank account for 5 years and not used, it could still be included in the property pool.
Yeah.
So it's really difficult to protect it.
But if it's received in a testamentary trust
as a resource,
then its starting point is it's a resource. So to me, without the family law experience, but to me what that does is shifts the onus of proof, because
the ownership isn't on the party.
Yeah.
The party doesn't own the assets then.
So no testamentary trust, the person who receives the inheritance is trying to reduce their attacking spouse's contribution to the inheritance and hope it's not included. If you receive it through a testamentary trust, then the onus of proof shifts, and it's the attacking spouse trying to drag that asset in as a property pool, divisible asset. But the starting point is it's not divisible. So it'll be included as a resource. So they'll look at, what are the needs? What's the equitable need of each party? But like that inheritance is not able to be like paid to the attacking spouse.
So then one of the other things that we look at is the party's future needs. So if someone has a larger income, one of the parties has a larger income than the other, then they would receive, the one who has less receives an uplift. So the person with the resource, they might not receive as big a portion of the property pool of what they have in their net assets, but they get to still keep the resource in the future.
Yes.
Yeah.
But I mean, I guess the harm, or when we're dealing with will makers, say you've got like baby boomer clients and they've got their adult children, their main objective is to make sure that the assets don't end up in the hands of their daughters or son-in-laws who go, when they're getting divorced. So the testamentary trust shifts the onus of proof, and rather than the inheriting child being on the back foot, they're on the front foot, and it's up to that attacking spouse to try and drag the inheritance in. And so I linked, and I'll link it again, but I've got this paper that I wrote 2013, so it's a bit old, but it's mostly still current, and it looks at how family law decisions have been treating assets in trust. So they're sort of looking at, well, who's in control? Is the trust the alter ego? Where was the source of the assets? Are the distributions going to, you know, a party to the relationship? There was a huge emphasis on control and the sort of who's benefiting. And so that's where we start looking into it and saying, well, as if testamentary trusts, you know, do you go one per adult child? Do you put all of the children into one testamentary trust and make them joint controllers so no one child has control, has all the distributions, can, you know, compel anything to happen with that trust? So the starting point to me, I say it's just game over on protecting that inheritance if you don't have a testamentary trust. So that gives you a leg up. It's not bulletproof with the testamentary trust, but then as advisors, we can start doing things like limiting or changing the control structure, being really clever about capital distributions coming out as loans secured against property and not distributions. Again, not bulletproof, but just moving along that spectrum of making it harder and harder for an attacking spouse. So that's my kind of thoughts on it.
The other thing that comes up a lot in family law as well, which isn't really to do with the trust or inheritance, but what parents often do is they gift or loan the parties money. And that can be, it's often an issue that comes up. And again, it's just if you are going to loan your children money, you need to do it in a full and proper way. You know, ensure that they are paying monies back to you. Ensure that there's a mortgage registered. Ensure all of these things, because otherwise, if it truly is a loan and it's kind of one of these family loose loans where it's like, here's $200,000 and you can pay it back, you know, maybe whenever you can, when you sell the house or something like that. If the parties separate, it can be seen as a gift if they haven't been treating it like a loan, and then there's no way of protecting it.
Yeah.
So
I think, be careful with strategies with, you know, related party loan, gifts and loans, document it, use the testamentary trust, like you just get such a head start. Okay, another question, because we've got to keep it kind of on time. What about when we're reviewing consent orders that deal with property and parenting arrangements? Is there anything that we should look at to align it in the context of the estate plan?
The thing that I could foresee is, you know, if there's any future payments under the consent order. So, you know, for example, you've done a property settlement where over time you've agreed that your payment will come. So it might be, you know, every 6 months for the next 5 years that they pay you a set amount. You know, you would want to make sure that that's documented elsewhere other than only the consent order.
I agree. And we'll come back to the other part because I've got a question about kids, but that kind of ties in. So that was Jacinta's question. Kirsty, you had a question about Section 95 of the New South Wales Succession Act. So I don't know all the equivalent sections, but basically where the parties agree not to challenge their wills. So, and obviously one mechanism where they can agree not to challenge each other's wills is under the consent orders, the property. I'm not using the right terminology.
Yeah, often people want to come up with arrangements where they make a promise under the consent order that monies goes to the children. Yeah. But you can't guarantee that the other side isn't going to change their will. So, you can't force what might happen in the future. So yeah. So we always sort of advise not to make those types of deals in consent orders because you don't know how the future might change.
Yeah. And I guess tying in with if you've got like staggered or staged payments to meet a consent order, because I don't know, I guess maybe they can't afford the whole payment up front or something like that, then to me, I always want to make sure that we continue that to happen under the estate, because otherwise you're possibly faced with a family provision application where that ex is trying to enforce what they should have received under the consent orders against the estate. So I would align them. You can kind of like say, well, this is the end of the deal, and I have to say, I have never made an application under Section 95 or the equivalent. If anyone watching has, put that in the comments and let us know your experience. But there's been quite a few cases. I did some research. Basically, you have to get it approved by the court. So they have to look at whether the agreement to not challenge is financially advantageous to the party who is agreeing not to challenge, prudent for them to enter into that agreement not to challenge, fair and reasonable at any time, not just then, and that they've had independent advice. So to me, it seems like these kind of decisions are going to be marred with the same issues that financial agreements, the family law financial agreements have historically, where they're just easily set aside.
The problem is that any of these types of agreements, life changes and things change in the future, and the way that you set out at 5 years ago to where you might be now, things move along, and so there's risk elements with these types of agreements.
So I found quite a few cases where basically, unless you have gone and had the court approve your agreement not to challenge, then it's really just an intention at that time, and it's not binding, and it's totally open to being challenged and considered. So feeding that into our other question about, well, if you've got payments due under consent orders and someone dies before fulfilling all of those, then I think that would totally give rise to a family provision application under the succession legislation to have those met. So to me, the party line that I've always had is that divorce and a financial settlement does not exclude the ex-spouse from being eligible to bring a family provision application. Because remember, when we're bringing family provision applications, it's a 2-step test. First step is you have to be eligible. Like, I can't challenge your will because I've got no eligibility. Second, even if you are eligible, then you need to satisfy that you needed further provision and what you received was not adequate. So that's where the consent orders with an ex-spouse come in. Well, they didn't get adequate provision if there's payments owing, and if they have, if you've satisfied and you've got financial closure, then I think it is really hard for an ex to have a second bite at the cherry.
Absolutely.
Okay, have you ever seen this? So there's like parenting orders. I'm just throwing out terminology that I don't even know. There's parenting orders where they agree who's going to look after the kids, and then one of the parents dies and they've nominated someone else to be the guardian of the kids.
My understanding is that it's purely a nomination. It's not binding in any way, and it always comes back to the parent. So the children. So and that's something that gets raised a lot in family law, because people say, oh, but if I died, I really wouldn't want him or her to look after the children on a full-time basis. But it's like, well, that's the parent, and that's the parent you chose to have children with. The other parent.
You must have some pretty blunt conversation.
So that's still the parent, unless there's a safety issue or something like that, where it would be completely inappropriate. Which that does come up. But generally speaking, we have orders, and I mean, I don't know the actual percentage, but it would be like 98% of orders that we do provide that both parents have equal parental responsibility. So equal parental responsibility means that both parents have the equal right to to make long-term decisions for the children's lives. And
Yeah.
that's where they live. And even if you don't have orders, equal parental responsibility is presumed anyway. So as a parent, unless the court has removed your rights to have equal parental responsibility, or you've agreed for one parent to have sole parental responsibility, the right stays with either parent for the child to live with them if one of the parents passes away.
I mean, that's what I've always understood when we're doing the estate planning context, and even then it's subject to, it can be appealed. So say it's the last surviving parent and they say who is going to look after them when there's no, the child's basically an orphan after that. Even then, whoever they nominate, interested parties can challenge that based on it's not being in the best interests of the children, right?
And so if both parents passed away, I don't know what would necessarily happen there, but if people are separated, it would go to the other. The children would go to the surviving parent. Yes,
and then if that parent then dies, I guess they can nominate in their will. But say other family members from the first parent to die, they could challenge that and say it's not in the best interests of the children to have that parents, guardian.
Yeah, and that can also happen when not about guardianship, but grandparents also have a right, or significant people in children's lives have a right to bring an application to the court to spend time with the child. So, sometimes there's grandparent alienation for different reasons. So, I mean, that's a whole other topic.
Yes. Okay, so I'm just checking, who have we got on still? So if you've got any more questions for us, send them through. Christiana, thank you so much. I agree with your comments. Grant, I think you had a question about how many don't have a will. 75%. And Grant, I'm doing a webinar next week instead of a live, so you'll hear more about that. But I'm going to talk more about those statistics. So watch that webinar. In the meantime, I think we've answered most of the questions that have come through. So, Caralee, one thing that I'm really interested in hearing from you, and I want you to share with everyone because I think they'll really get a benefit, is if they have clients who come into the office and have going through a separation, and this is maybe more for the financial guys, then obviously any family lawyers, you'll just sort that out if there's any family lawyers watching. But for the people who don't have that family law expertise in-house, what resources do you have available as part of the online technology solution? Okay, so I've got an online program, and that helps people to walk through a family law process if they don't want to engage a family lawyer for one reason or another. And like I said before, 71% choose not to, or can't afford to, to have a lawyer, or don't want to. So I have an online process for that, or other than that, obviously seek advice from, refer them to a local family lawyer that you know and trust in your area. Okay, and so do they pay to go through the course? I've got some free resources on there, which can help people through the separation process as they're moving through separation. But I've also got a paid course as well, which is a far greater detailed type of course to help people through. And it can be maybe a first step before they retain a lawyer as well, just to sort of get them moving and to see what their next steps might be, to sort of learn to see at what point they might need to engage a family lawyer as well. So, because people struggle to recognise when they need to engage a family lawyer and how they go about it, because often these are the mums and dads who have never retained a lawyer other than for conveyancing or something like that. So it's a very scary step for them. And you've got a lot of really practical resources up there, which is what I love. So it's not all legal stuff. It's okay, so you're leaving. What do you do before you actually move out of the house and things like that. Like what information and documents do you need to take and make sure you have? And
I just answer a lot of questions, you know, because people really are at a loss as to what they need to do. And, you know, they sort of, what about bank accounts, and what do we do with this, and what do I do with that, and, you know, can I get my money put in my own account, and what money can I have access to, things like that. Because people genuinely don't really want to do the wrong thing. They want to do the right thing, but they don't often know what that is. So I have a lot of resources on there to checklists and bits and pieces like that to help people.
So I think that's an amazing resource for like first point of call. If you are an advisor out there who's got a client going through a separation, obviously get them to update their will, but secondly, like, go and check out
and my podcast has got lots of like really good practical information as well.
So the podcast is called Divorce Confidential. How do they find you online to access some of these online resources?
Just under my name, which is Caralee Fontenele. So if you just Google Caralee,
we'll put the link in the video description, so you'll be able to flick off over there and then check it out, because I think this can be a really big value add for you to point your clients in the right direction. So we've gone over, as always. Next week, I'm going to send out a bit of an announcement, but we're doing a proper webinar next week. I'm just trying something different because we're limited with the screen sharing and the ability to use slides, and I'm going to allocate a whole hour because I think the half-hour time slot is very tight. So join me next week in the webinar, and I think we'll finish up. Thank you so much,
thanks
Caralee.
for having me on your live.
Delight.
It's the first time I've done a live, and it's just not as scary as
No,
it seems.
it's not scary at all. And thank you to everybody who has joined us live, and everyone who has tuned in after and watched us. Any questions, throw them in the comments and we will just check them out after as well. Bye. Thank you, Jacinta. Bye.